In the 1976 case, Washington v. Davis, 2 Black applicants were ejected from the Washington, D.C. Police Department. The applicants challenged the police department's use of Test 21, a written service exam. They argued that they failed Black applicants more than white applicants, claiming that it was racial discrimination and that it violated the Due Process Clause of the Fifth Amendment. The case posed the constitutional question, does a government action that has a disproportionate impact on a racial group violate the Equal Protection Clause even if there is no evidence of discriminatory intent? In a 7-2 decision, the Supreme Court decided that a law or government practice that disproportionately affects a racial group does not violate the Constitution's equal protection principles unless there's proof of discriminatory intent. The precedent is that the Supreme Court established that to prove a violation of the Equal Protection Clause, a plaintiff must show discriminatory intent, not just disparate impact. The opinion of the court states that the police department's use of verbal skills test 21, to hire police officers failed more Black applicants than white. This did not violate the Constitution because there was no evidence that it was designed or used with racial bias or intent. Dissent Justice Brennan believes that when focusing only on intent, it sets the bar too high for proving racial discrimination. Laws that produce significant racial disparate effects without intent should raise constitutional concerns because they impact people's constitutional rights. Brennan believes that impact matters just as much as intent, and that the court's ruling only weakened the protections of the Equal Protection Clause for victims of discrimination. The petitioners argue that Test 21 discriminated against Black applicants because a significantly higher percentage of Black applicants failed compared to white applicants. This disparate impact is a violation of the Equal Protection Clause of the Fifth Amendment's Due Process Clause because it did not provide equal opportunity for all of the applicants. There is no intentional discrimination, but the racially disproportionate results alone make the test unconstitutional. They believe that the government laws and policies that have significant effects on racial minorities should be presumed discriminatory even if there is no evidence of racist intent. The respondents argue that Test 21 was designed to measure the verbal skills needed for police work, but not to discriminate between races. It was neutral and was administered equally. The disparate impact on Black applicants was unintentional. Essentially, they argued that the proof of unequal results of the test is not enough to violate the Constitution. This is because there is no evidence of purposeful racial bias. The test did not violate the Constitution because the Equal Protection Clause only prohibits intentional discrimination.